Hello, everyone. Welcome to the 2023 Hot Topics in Environmental Law Summer Lecture Series. I'm Jenny Rushlow, Dean of Vermont School for the Environment, and we're very pleased to welcome you here today. Each of these talks is worth one Vermont CLE credit, so if you'd like to claim that credit, just keep track for your records. And we will have time for Q&A at the end of the presentation today. If you're watching on YouTube or Facebook on the VLGS pages, you can enter your questions into the chat or the comment space anytime during the presentation, and we'll collect them all and get through as many as we can at the end. Today, we're very pleased to welcome Bob Percival. Professor Percival is the director of the Environmental Law Program and the Robert F. Stanton Professor of Law at the University of Maryland, Francis King Carey School of Law. He clerked as a law clerk in the Ninth Circuit and for Supreme Court Justice Byron White, and spent 6 years as an attorney for the Environmental Defense Fund. He served as visiting professor at Harvard Law School and Georgetown Law School. He is the author of the most widely used environmental law casebook. He was a Fulbright Scholar at the China University of Political Science and Law in Beijing in 2008, and has worked with China's Supreme People's Court, the National People's Congress, the Chinese Ministry of Environmental Protection, and the China Council on International Cooperation for Environment and Development. Professor Percival joins us this summer, as he has for many summers, teaching the course Environmental Governance in the Developing World, which includes leading a group of students from the class to China for a field study experience, which will happen in August. And today his talk is titled, Can State Tort Litigation Do to Big Oil What It Did to Big Tobacco? Please join me in welcoming Bob Percival.
Thanks. It's a real pleasure to be here in what's been the rainiest summer since I've been coming to Vermont for over a decade now. I'm going to share my screen now. And the topic for today is focused on whether state tort lawsuits against the major fossil fuel companies can mimic what happened with the state litigation against tobacco and cigarette companies that ultimately led to the master settlement agreement and an over $200 billion settlement. Now, of course, climate change is on people's minds like never before. The record heat seems to be occurring all around the world every day, extreme weather events that are making this a really important public policy issue, and I'm sure tempting many environmentalists to say, I told you so, given all the climate denialism that they were greeted with when they started warning about climate change dangers decades ago. Not surprisingly, litigation involving climate change issues is growing all over the world. As this chart shows, seems to be increasing almost every year. And in most of the developed countries of the world, you're seeing climate litigation. This chart doesn't include the cases brought at the state or local level. Just a few weeks ago, the Grantham Center did their snapshot of global trends in climate litigation over the last 12 months. And they noted that more cases are being filed against corporate actors with a more complex range of legal arguments. Around 20 cases have been filed by US cities and states against the carbon majors, and they're now likely to go to trial, which is the result of the Supreme Court refusing to step in when they denied cert in April, and we'll talk about that in detail. The more than 24 cities and states now are suing major oil companies. And in April, their last effort to get the Supreme Court to intervene failed. And so they're kind of out of options now, and it's likely these cases will go to trial. Now, in fact, what most of these cases allege are not violations of any federal law, but simple garden variety consumer fraud, often in violation of state consumer protection statutes, and state common law. The argument is that the oil companies promoted their products and funded disinformation campaigns while lying about the risks of climate change that their products would contribute to. And these cases generally seek damages on the theory that the states and cities are having to spend money to adapt to climate change. They're not seeking any court to go out on a limb and issue an order formulating mitigation policy and ordering reductions in greenhouse gases. And this is strikingly similar to what happened with the tobacco litigation. So I'd like to just sort of review the history of how state tort litigation tamed big tobacco a quarter century ago. It was almost 50 years ago that the US Surgeon General released the landmark report on smoking and health that found overwhelming epidemiological evidence that smoking caused lung cancer. And yet it was not until decades later that the Food and Drug Administration considered potentially regulating tobacco products. It had long taken the position it didn't have the legal authority to regulate tobacco products. But during the Bush administration, and this was the first Bush administration, the commissioner of the Food and Drug Administration, David Kessler, got wind of the notion that what the cigarette companies were doing was deliberately manipulating levels of nicotine in order to hook smokers on their products. And under the FDA statute, the Federal Food, Drug, and Cosmetic Act, the FDA had authority to regulate drug delivery devices. And when Jeffrey Wigand, who had been head of research for a major tobacco company, became a whistleblower and went public with his claim that the companies were deliberately manipulating nicotine levels because they knew nicotine was addictive, Kessler realized that now cigarettes were drug delivery devices, that they were being used to deliver nicotine so that the purchasers of cigarettes would be addicted to their products. So the FDA proposed and adopted far-reaching regulations to control the marketing of tobacco products. They were challenged in court, in the meantime, the House of Representatives hauled the major CEOs of the tobacco companies before it, where they all testified under oath that they believed nicotine is not addictive. Of course, Wigand said that they were lying and committing perjury when they did so. Eventually, the regulations, I believe, were issued in 1996. It took 4 years, but the Supreme Court, by the barest of majorities, 5-4, in an opinion by Justice O'Connor, struck down FDA's effort to regulate tobacco products. She ruled that since the FDA statute requires that products be safe and effective for their intended use if they're approved by the FDA, that since cigarettes were inherently unsafe, Congress could not have meant for the FDA to have jurisdiction over tobacco products. Now, fortunately, 9 years later, the US Congress, in an overwhelmingly bipartisan fashion while President Obama was in office, enacted the Family Smoking Prevention and Tobacco Control Act that explicitly gave the FDA the authority that the Supreme Court didn't see in their existing legislative authorities. Now, while the FDA was having to spin its wheels because of these legal obstacles, it was state tort litigation that really brought the tobacco industry to its knees. A number of individuals who had gotten lung cancer had brought tort suits against tobacco companies, but they were pretty much outgunned at every step by the tobacco companies. They engaged in what was called a scorched earth strategy, in which they made every case prohibitively expensive and were able to raise defenses like assumption of risk, especially because Congress, after the Surgeon General's report had come out, had adopted the Cigarette Labeling and Warning Act that required warning labels on tobacco products. And in fact, that had privately been welcomed by the tobacco companies because they thought they were buying insurance against liability litigation, because they could argue, we warned you. It wasn't until 1994, 30 years after the Surgeon General's warning, that Mississippi Attorney General Mike Moore brought the first healthcare cost recovery lawsuit by a state against the tobacco companies. This was not litigation claiming that by an individual claiming they had been harmed. Instead, what the state said was that you had raised the costs of medical care for state governments because of your dangerous products causing so much harm to public health. He argued that the companies had conspired to conceal the health hazards of smoking and had hid damaging research from the public. That lawsuit spurred other states to file lawsuits. And in Minnesota, the Minnesota Attorney General succeeded in overcoming industry claims of attorney-client privilege and obtained in discovery some really devastating documents that showed that the tobacco industry had known about the devastating health effects of their products, but instead they had engaged in a conspiracy to persuade the public that the products weren't harmful. One of the things that was discovered was a December 14th, 1953 meeting at the Plaza Hotel in New York with the Hill and Knowlton public relations firm, where they decided on how they were going to respond to initial claims that cigarette smoking was related to lung cancer. This is even before the Surgeon General's report. And one of the things the industry decided to do, they wanted to assure the public that all was well, that they were looking out for their health and doing research to make sure their products were safe. So they created this bogus tobacco industry research committee that was designed to make it look like they were running their own scientific studies and finding that all was well. And the next year, they ran this full-page ad in major publications throughout the United States called A Frank Statement to Cigarette Smokers, where they said, well, there's been some suggestion that our products are harmful, but all those studies upon careful scrutiny have fallen apart. And we have this new tobacco industry research committee that's going to be looking after you. And they even ran lots of ads saying that doctors love to smoke and anything to reassure smokers that they didn't have to worry about the health effects. Now, as the tort litigation multiplied, eventually the tobacco companies saw the writing on the wall, and in 1997, they proposed a $365 million settlement that would have to be approved by Congress. But when it got to Congress, Congress kept increasing the size that they wanted, and the companies ultimately withdrew it. But then in November 1998, after 5 months of negotiations with the major tobacco companies, 8 state attorneys general announced that they had reached a settlement with the tobacco producers, and they gave the other states 5 days to accept or reject the settlement terms. So on November 23rd, 1998, 46 states, the District of Columbia, and 5 territories signed the master settlement agreement with major tobacco producers. Some states had actually criticized the litigation initially, but once the settlement was reached, they all rushed to join it. The 4 states who didn't sign it were states who had already reached their own separate settlements with the companies because they had sued them earlier. And this was designed to resolve all existing legal claims by the plaintiff states against the tobacco industry. Now, what were the terms of the settlement? The companies agreed to significant restrictions on their advertising and marketing of tobacco products. They also agreed to fund a $1.5 billion anti-smoking ad campaign. A very significant portion of the settlement was they had to open up their files and make public all their secret documents, and that they had to disband the industry front groups like the Tobacco Industry Research Committee and pay all plaintiffs' attorneys' fees and costs. And the terms of the settlement were that after a $12 billion upfront payment that would be made over the first 5 years, the companies agreed to pay $206 billion to the states during the period from 2008 to 2025. And those payments were to continue in perpetuity, depending upon levels of cigarette sales and levels of inflation. Because this was actually not a settlement involving the federal government, each settling state had to embody the settlement in a consent decree that was filed in state court in a way that was then enforceable against the companies. And the settlement also created a $50 million consent decree enforcement fund to make sure the companies complied with its terms. Companies also agreed to fund a $250 million foundation to combat teen smoking. Now, the next year after the state settlement, the federal government actually brought its own RICO suit against the tobacco industry in federal district court in DC. RICO stands for Racketeer Influence Corrupt Organizations Act. And this was legislation that was adopted to make it easier to prosecute organized crime. If you could show that there was a conspiracy behind some bad acts, then anyone involved in that conspiracy could be held liable for it. It was kind of like the Superfund legislation for organized crime. The federal government alleged that the industry was involved in a conspiracy to conceal the dangers of smoking, addiction, secondhand smoke, nicotine manipulation, marketing to youth, and suppression of information. And in 2004, the DC Circuit ruled that the RICO Act could not be used to require the companies to disgorge their past profits, but that it could be used to get injunctive relief to prevent or restrain future wrongdoing. And in 2006, when the case went back to the DC District Court, Judge Gladys Kessler issued a 1,500-page decision that lambasted the tobacco industry for its practices throughout history and issued injunctive relief to govern the marketing practices of the industry in the future and to require not only document disclosure, but publication of corrective statements. She's found that over the course of more than 50 years, the tobacco companies had lied, misrepresented, and deceived the American public, including smokers and young people they avidly sought as replacement smokers, about the devastating health effects of smoking. Her ruling was appealed, modified slightly on appeal, and the Supreme Court denied cert, so it became final. And as a result, in November 2017, the tobacco companies were required to start a massive ad campaign to admit that their products kill and are addictive, to try to compensate for their massive disinformation campaign in the past. Here's the actual text of the court-ordered corrective statement. It was pretty hard-hitting in saying that smoking kills 1,200 Americans every day. It's addictive. Nicotine's an addictive drug. It's not easy to quit. That claims that some cigarettes are low tar, light, ultralight, mild, and natural don't make them any safer. that cigarette design had been manipulated in order to make them more addictive, and that secondhand smoke kills more than 38,000 Americans each year. So that was what was sort of the taming of the big tobacco industry. Of course, rates of smoking in the US have declined fairly substantially, in part because of this, although there's still a lot of smokers out there. Now I want to make the analogy to climate change litigation, but first, to set the backdrop of how the oil companies are trying to defeat climate change litigation, it's important to look at climate change litigation in federal court. Now, the major case that the Supreme Court decided was Connecticut versus American Electric Power. In 2004, several states sued the major electric utilities whose coal-fired power plants generated huge quantities of greenhouse gas emissions. And they sued in federal court using the federal common law of nuisance. That's the law that the Supreme Court around the turn of the beginning of the 20th century started using to address interstate air pollution from smelters, the famous Georgia versus Tennessee copper case. And when the case got to the Supreme Court ruled that, yes, there was this federal common law of nuisance, but it found that it had been displaced by the Clean Air Act because the Clean Air Act, particularly after the Massachusetts versus EPA decision, gave explicit authority to EPA to be the one to decide how to regulate emissions. What their lawsuit had sought was an order from a federal court requiring these utilities to gradually reduce their greenhouse gas emissions. This was not a suit for damages. It did not involve state law or state common law at all. Justice Ginsburg, in the opinion for the unanimous court, basically said EPA is the expert agency that's better equipped to decide how to formulate a plan to abate emissions of greenhouse gases. Now, that case has been cited in subsequent cases for the notion that, well, the Clean Air Act should supplant all climate litigation. It is true that there was this case that the Ninth Circuit decided in 2012, where an Alaska village said, sea level rise is going to wipe us out. We want the oil companies to pay to relocate us. The Ninth Circuit said, in light of the American Electric Power decision, that's preempted by the Clean Air Act. And the case that the oil companies have kept hanging their hats on, another federal common law nuisance suit brought in federal court by the city of New York against Exxon, resulted in a Second Circuit ruling in 2018 that basically said the federal common law of nuisance has been displaced. And the judges said, and we think because climate change is a global problem, that's only fitting that federal common law should not be used. Now, of course, in the American Electric Power case, Justice Ginsburg was explicit in saying, we're not saying anything today about state climate law. And notice in a moment how the oil industry lawyers have gone out of their way to distort the city of New York decision to try to claim there's now a circuit split. And a final note on federal litigation, of course, we're all familiar with the Juliana case, a very clever litigation strategy. These children sued the federal government for having known about the dangers of climate change for over half a century and having done nothing to protect future generations or present generations from the impact of it. This case was before a federal district judge in Oregon. It was about to go to trial when the Supreme Court intervened, when the Justice Department made an emergency appeal to them after the Ninth Circuit refused to stop the litigation. And the Supreme Court very pointedly said the Ninth Circuit should step in and deal with this case because it had very broad claims about how there was a federal constitutional right to a healthy atmosphere. And eventually Judge Aiken was bludgeoned into certifying an interlocutory appeal. But one thing to note about this, and I think it's very revealing, both Justices Thomas and Gorsuch would have just wiped out the Juliana case, said you can't bring climate litigation. So it's clear there's two, probably three votes, because Justice Alito would join them in this, although he's had to be recused from most all climate litigation because he owns stock in big oil companies. Finally, the Ninth Circuit then, when the case got there, it was kind of a dream panel of three judges appointed by President Obama. The 2-to-1 majority said climate change is a catastrophic problem, but the problem is, as an Article 3 court, we don't have the power to address it. We can't formulate a plan to require emissions reductions. Judge Staten, dissenting, said that you're throwing up your hands in the face of like an asteroid about to hit the Earth. I was telling my students, actually, a more appropriate analogy would probably be from Al Gore's Inconvenient Truth of the lobster slowly boiling as the pot kept heating up, because as we've seen, climate change is not a problem that just suddenly happens overnight, although it's suddenly appearing all over the world, its effects as a result of what's happening today. Now, very different type of litigation is the climate change litigation that's now going on in state courts. And dozens of cities, counties, and state governments have filed suit against the big oil companies. And they very carefully have formulated their complaints as violations of state law, state consumer protection law, state tort law. They've argued that the oil companies funded a climate denial and disinformation campaign, lied about the risks of their products, and we're all suffering as a result of that, and that they should be given damages to help adapt to the negative effects. Now, the oil companies, they have one consistent line that they always, whenever this litigation is discussed, they say it's not doing anything to reduce the problem of climate change. And so it's a waste of money. Well, it's true that the past is the past, but what it seeks to do is it seeks justice for the past sins of the oil companies, their climate denial. And it's only just that, having engaged in the same tactics the tobacco companies engaged in, they now could be held liable for the costs that are happening today to cities and counties and states all over the United States. Now, these cases have not yet gone to trial, but they could go to trial shortly. And some of the documents that have been discovered, I mean, it's well known that right before the Kyoto Conference of the Parties to the Framework Convention on Climate Change in December 1997, the CEO of Exxon, Lee Raymond, gave an address to the World Petroleum Congress meeting in Beijing. And he basically said, don't agree to control greenhouse gas emissions. Climate change is so uncertain, it's not anything we should be worried about. What we should be worried about is providing energy, which is the key to a better environment for Asian and Pacific countries. And of course, he wasn't successful. The Kyoto Protocol was signed in December 1997. And documents that have been disclosed in discovery show that Exxon scientists had really good climate models that they thought were pretty reliable. And yet the response of the company executives was, let's keep emphasizing the uncertainty in order to cast doubt on whether climate change is real. So this is a chronology of the various lawsuits that have been filed. And a couple of points, the oil industry filed emergency motions with the Supreme Court to try to intervene and stop trials. Their primary tactic, though, has been to take all of these cases that are filed in state court and remove them to federal court. Now, under the federal removal statutes, you can do that, but only on limited circumstances. And the removal statutes were shaped in part by the experience of the civil rights movement in the South. And so one of the limited grounds for removal is that if a federal officer is being sued in order to avoid a biased state court biased against the federal government. And when they made these removal motions, one of the preposterous claims that the oil industry made was what I call the feds made me do it. They point to the fact that they had contracts to sell oil to the Defense Department as somehow meaning that they were helpless and should not be held liable for any harms that their disinformation campaign has engendered. And in fact, every single federal court has said this is not appropriate for removal and has remanded those cases to the state courts. But the oil industry then appeals the federal district court remand orders to the US Courts of Appeal. And every one of those has said these cases are state law claims. They belong in state court. They don't belong in federal court. Now, they did hit on a winning strategy in this case involving the city of Baltimore. They appealed to the Supreme Court to intervene when the Fourth Circuit upheld the remand order by the federal district court in Maryland that would have sent it back to the Circuit Court of Baltimore City. And the grounds for seeking cert was an incredibly narrow procedural conflict in interpretation of the federal removal statutes. The argument was made that because of one opinion by Judge Easterbrook in the Seventh Circuit that said, when you're considering a remand order on appeal, you can look at any possible grounds and not the narrow ones in the statute. And on the basis of that circuit conflict, the court took it, but not to review the merits of the climate litigation. And at oral argument on January 19th, 2021, what had happened was once the case was in the Supreme Court, suddenly the oil companies added a section to their brief that said, wait a minute, now that we're before the Supreme Court, you know, there's these dozens of state court climate suits. Why don't you just wipe it all out? Climate change is a global problem, so it can only be dealt with by the federal common law of nuisance. It's not a matter of state law. And at oral argument, Justice Barrett, whose father was a Shell oil executive, said, don't you think it would be fairly aggressive for us to resolve the federal law question here, given that, you know, this is a case that was granted cert on the basis of this technical point involving removal. And of course, the oil industry lawyer says, well, we got all these cases, why don't you just decide it all at once? Now, of course, we know that Thomas and Gorsuch and probably Alito would, in fact, like to wipe these suits out. When the case was finally decided, the court agreed that courts of appeal went on a 7-1 vote with Alito recused because he owns oil industry stocks. On a 7-1 vote, the court ruled that courts of appeal should consider all possible grounds for removal. So cases then go back to the lower courts and they consider all possible grounds for removal, and they unanimously find that these cases belong in state court, not in federal court. And of course, when the Eighth Circuit ruled against them in a case brought by Minnesota Attorney General Keith Ellison, ExxonMobil issued its normal statement that this doesn't advance efforts to address climate change, will continue to devote billions of dollars to meet today's energy needs while leading the way in a thoughtful energy transition towards net zero carbon. So they go back to the courts of appeal, US courts of appeal. They all say they should be remanded. So once again, this year, every single case they bring to the Supreme Court, and they're now being open about their motive, it's to beg the Supreme Court to just say federal common law of nuisance trumps all state law, even for garden variety consumer protection and tort claims, and you should just wipe out all these lawsuits. But they got a big surprise. On April 24th, every single one of their cert petitions was denied, with Justice Alito taking no part because he owns the oil stocks. So what you have here is a pretty strong statement by the Supreme Court that we're going to respect federalism, that these truly state law claims, and in fact, the court has a long track record of staying out of state tort litigation, no matter how big the stakes are for industries. And so it looks like that's what they're going to do in these climate cases. Now, a new twist has been that some of the state plaintiffs are amending their litigation to add RICO claims, just like the federal government did against the tobacco companies. This op-ed by the lawyer who had represented the federal government in the RICO litigation against the tobacco companies said the same is true of the oil companies. They've engaged in the same kind of disinformation and deception concerning the health effects of their products. And so they could be liable for RICO claims. And last November, the Commonwealth of Puerto Rico, where my son lives, filed a RICO claim against the tobacco, the oil industry on that basis. And just a few months ago, the city of Hoboken, New Jersey, amended its lawsuit to add a state-level racketeering charge, saying that there are 3 stages to the oil company scheme to defraud. While their own scientists were warning them about the impact of fossil fuel combustion, they decided to wage a massive disinformation campaign, and they've been engaged in concerted greenwashing to portray the oil and gas business as part of the climate solution. So the stakes are getting higher for the oil companies, and they're being besieged by all these lawsuits. Now, what about the master settlement agreement for tobacco? The primary criticism of it is what happened to all the money? It was paid, and it's still being paid by the tobacco companies, but only a pittance of the billions was used to combat tobacco use. Much of the money was plowed into state flush funds or used to patch budget holes. Some states even sacrificed future payments in order to get much smaller but immediate infusions of cash, like going to a payday lender. And so instead of all this money being plowed into anti-tobacco efforts like people thought would happen, that hasn't happened. Now, there were some exceptions. In Ohio, a bipartisan group of legislatures agreed on legislation that created a separate entity that was supposed to permanently and irrevocably ensure that money was spent on anti-tobacco programs. They did so for 1 year and then said, well, we've already diverted enough money to that cause, so we can use the rest of it for the state's general fund. And several other states did create private foundations to get the money. But after a few years, the same pattern prevailed. If you've got a ready source of money, greedy state legislators have uses for it to stop their budget deficits. Florida was the big exception. A state constitutional amendment was adopted through a voter initiative that directed the MSA money to anti-tobacco efforts. On the 20th anniversary of the Master Settlement Agreement in 2018, the Campaign for Tobacco-Free Kids estimated that only 2.6% of the Master Settlement Agreement funds were spent on tobacco cessation and prevention measures. I must editorialize that my state of Baltimore, where I teach, actually use the money for tobacco prevention. They gave us money. We created a tobacco control clinic. I actually taught a seminar for several years on tobacco control and prevention. And so they were one of the better states at how they allocated those funds. Now, of course, recently we've also had this national settlement involving the opioids litigation, that it's clear that pharmaceutical companies that were marketing opioids did it in a really irresponsible manner and continued to do it when it was clear that they were addicting and killing many, many people. And the first state to sue the industry, the pharmaceutical industry, was Oklahoma, which had won a $465 million judgment against Johnson & Johnson for flooding the state with opioids. But the Oklahoma Supreme Court reversed that and said you couldn't use nuisance law in order to challenge the marketing and manufacturing processes of those companies. But now so many lawsuits have been brought that in July of 2021, 3,000 plus lawsuits were resolved in a $26 billion settlement with not only opioid manufacturer Johnson & Johnson, but distributors including McKesson, AmerisourceBergen, and Cardinal Health. This was much more complicated because, like the oil industry litigation, it involved not just the states like the tobacco litigation, but also counties and cities and health providers and the like. There's supposed to be $21 billion paid over 18 years. By the distributors, Johnson & Johnson paying $5 billion. In 2000, agreements were reached with CVS, Walgreens, and Walmart, and 2 additional manufacturers. So very substantial sums of money, not nearly as much as for the tobacco master settlement. But they also have learned from the master settlement agreement experience, and they've embodied provisions to ensure that at least 85% of the funds go to measures to abate the opioid epidemic. And they've actually created some safeguards through a clearinghouse and the like to keep track of where the money goes and to keep track of opioid shipments in the future. So, in conclusion, there are some promising parallels between the tobacco and litigation and state climate litigation. And it'll be very important to see what evidence is developed at trials. Companies have been trying to avoid them like crazy because they know it's not going to be good press for them when all the information comes out about what they knew about climate change when, and how they try to deceive the public about it. But there are some important differences. Unlike the tobacco or opioid litigation, the fossil fuel industry was not selling an addictive product that we consumed in our bodies. And so the harm that their outrageous behavior didn't happen directly by killing us, by killing our bodies. But what it did do was it contributed to the fact that we were so slow to respond to the climate change problem. And we're now seeing today our bodies are being affected in many parts of the world by truly extreme heat and a host of other problems that we've been worried about for some time. And that will make the causation a little more difficult, but it's also true that in intervening years, climate science is getting really good at what's known as climate attribution, determining when there's a major severe weather event, to what extent was that exacerbated by climate change. And so climate attribution science now has gotten to the point where you can have expert climatologists get to the jury on what should be the share of liability that this particular defendant is responsible for, given what's been proven about their behavior. The day of reckoning is coming for the oil industry. The question will be whether they will decide to follow the path of the tobacco and opioids industry in trying to get it all wiped out, not by right-wing judges on the Supreme Court, by fiat, but rather through a settlement agreement that could provide substantial funds that cities, counties, and states desperately need to adapt to the ravages of climate change. So I'll stop sharing my screen there and open it up for questions.
Thank you, Bob. Okay, so for the audience, we do have a few minutes to ask some questions. And if you do have questions, please enter them in the chat or the comment space on YouTube or on Facebook, and we will get through as many as we can. To start things off, Bob, the timeline that you showed for the opioid litigation seemed like a fairly short turnaround from the initiation of litigation to getting to a master settlement. Why was that so much faster than tobacco and seemingly climate litigation?
Well, I think it was absolutely clear that there were huge numbers of deaths caused by misuse of opioids. And the data that became available about how the industry literally flooded some of these small rural towns with so many more opioids than could possibly have been legitimately prescribed was just so damning. And because it involved sudden deaths that were happening throughout the United States, they realized they were in really big trouble. I mean, the Sacklers basically tried to buy off criminal liability for themselves because it was almost like complicity in murder. And you can say the same was true of the tobacco industry, but at least smokers had to initially choose to use their addictive product and get hooked and then get exposed in a way that would cause a fatal disease there. And I also think that the precedent of having had the tobacco master settlement agreement helped make this much easier. The lawyers knew how procedurally to deal with it. And there also was, tobacco settlement was much harder because you had to coordinate all these states. Ultimately, the opioid settlement was the result of federal multi-district litigation, where all these federal lawsuits had been filed and the federal courts were able to assign them to one particular court to handle the multi-district litigation, which always is helpful in facilitating settlements as well. And you may see something like this. I mean, 3M has just reached this kind of global settlement with respect to its production of PFAS. I suspect DuPont will need to do one shortly as well. And those are primarily with water suppliers because PFAS have gotten out there and escaped into the environment so much. It's interesting now, there's all this publicity about the Wall Street Journal investigation of lead telecommunication lines that have been found all over the country. I actually think lead's quite different from PFAS because unlike PFAS and MTBE, lead doesn't move so quickly through the environment like they do. So the cleanup there will probably be a lot easier to do, and it'll be a lot more difficult for anyone to prove personal injury just because there was some soil contamination with those lines.
It was interesting to hear the kind of some of the details of the tobacco litigation in terms of, specifically what was required to be in the ads after the settlement and, the secret documents that were required to be shared. What do you think that defendants have learned since the tobacco litigation that might shape either their behavior now or how they might go about litigating these cases now? And I mean, climate defendants, drug companies, things like that. And it's a very different world now too, with,
Yeah.
the internet
I mean,
exists.
the tobacco experience was really damning for all the tobacco industry lawyers who were involved, because they deliberately structured things so that they could make colorable claims of attorney-client privilege in what was basically a campaign to defraud smokers and lie. Now, I suspect by now the oil industry is a little more clever than that, but a lot of their conduct goes way back, and they weren't so clever back then. So you'll probably see emerging from some of these trials some pretty amazing documents that show, and it also shows they employed the best scientists. The Exxon scientists, they knew what they were doing about climate change, and their forecasts were pretty much spot on. And they're now trying to claim, well, we should not be back looking. We should just be forward looking, and we're going to help with the solution. And this litigation does nothing to help with that. Well, it does. It may deter future abuses, but it's also justice for past sins, and they've committed lots of them.
That's a great point about how, though the climate litigation is happening now, a lot of the statements and documents and videos that are coming out in discovery do go way back to even before tobacco litigation times. And perhaps fortunately for plaintiffs, history has not been kind to the type of behavior that we saw then. The types of statements that were made in correspondence, feels even more egregious because it happened at a time when people didn't think they could be caught for saying such things. So in some ways that may help the plaintiffs. I'll ask you a question that some students asked me in my climate change law class, which is, you talked about the Connecticut v. American Electric Power case and what that means for tort litigation. And basically what Ginsburg said in that case is that EPA is the expert, and we leave it up to them to decide how to regulate climate change. Now we have the West Virginia case, which says, well, actually, EPA isn't really the right agency to be making climate regulations. They know they do nothing with the power grid, and really confines the expertise of EPA in a very different way than Ginsburg described it, or as Kagan describes it in her scathing dissent. So what impact do you think the West Virginia case has on the Connecticut v. AEP case? Does it somehow amend its impact?
It's hard to reconcile the two, because, and I think it's a case where the Supreme Court was itching to place a crown on the head of the major questions doctrine, which it is now used in a case where there truly was no standing for the states to challenge Biden's student loan cancellation policies. And it's almost as though the Supreme Court is saying, we don't care who the expert is. We're not going to let you do anything that Congress doesn't, through new legislation, explicitly authorize. Now, the new EPA proposal for regulating greenhouse gas emissions from power plants, I think is crafted very well to challenge the court once again, because it kind of responds to the way the court parsed the language of that section of the Clean Air Act in the West Virginia case. So we'll see what happens. But I mean, I think the larger lesson from West Virginia is market forces did so much more to reduce greenhouse gas emissions from the power sector that the Clean Power Plan was pretty irrelevant at the very time that the industry was telling Supreme Court this was an emergency. You had to stay it because there'd be such dire consequences. So you're seeing that in a lot of cases, like with the tobacco industry, market forces now, they're trying to invent new products and new ways of appealing to youth. but it's a dying industry. And that's because the awareness of the health dangers of smoking is so great, and efforts to combat the addiction have increased. So, we're becoming a healthier society, and sometimes our environmental laws may act more like cheerleaders on the sideline for what happens when the power energy infrastructure grains, largely due to market forces around the world.
If we had another hour, I would love to talk to you more about the new regulations. But I'm going to get the hook from Courtney because you have class at 1 o'clock. So we'd better let you go. So thank you, everybody, for attending the talk. Thank you, Professor Percival, for a great presentation. Always love to hear your take on Supreme Court matters and everything else. And for our audience, our next talk will take place online on Thursday of this week, and we hope we'll see you there. Thank you.
Thanks.